Okay, hi, hello. My name is Sarah Blakemore. I am the coach of the UT undergraduate moot court team. In this video, I am going to try to teach you how to brief a case. This is, of course, how I brief a case. There are many different ways to brief cases. Some people will go to bat with you about the way that they brief a case. They might be doing a better job than me. I am open to any sort of suggestion. Briefs are really a personal kind of affair. Briefs for the purposes of moot court are basically the first thing you're doing within your research. And briefs, of course, when you go to law school, if you go to law school, are most of the way that you're going to take notes. So what is a brief? Okay, so I am a rhetoric major, and I have just noticed that the law relies on rhetoric. It uses a different kind of language. It uses legalese, and it relies specifically on the words that it picks. And it picks the word briefs for basically just your notes. That's part of its rhetoric, that it's a brief, but it's your notes. In moot court, you are going to do about 20 of these, one for each case that is assigned in the case that's assigned by AMCA. And there will be about 10, 9 or 10 on each side of the first issue and the second issue. So you'll want to brief all 20 of those. And then, of course, I encourage everyone to get their personal spin on this. You don't have to do exactly what I do here, but these are pretty much the basics. This is actually the way my teacher taught me how to do it at the University of Texas. Shout out to Dr. Benjamin Gregg. First, you're going to start out with writing the facts of the case. Just what happened, how did they get into this controversy, how was the case filed, and what did they argue, what did they decide in the lower court. Next, you should have the constitutional question. This is just the question. We have constitutional questions, but in any case, the justices or the judge is only going to answer a certain question, and in appellate law, you actually are going to provide what you think the question is to the judge in your briefs. And you'll have the opportunity to do that if you join the team. We have a brief competition. You should record the votes on Oyez. They have a very nice little graphic of each of the justices, and it shows them on either side or grayed out if they're dissenting. It's cute. It has the votes. Write them down. It's important because if something's unanimous, that means the court is speaking very clearly on it. If there's a lot of dissent or a lot of concurrence, that means that the justices are not all settled on this one specific portion of law. So it matters. The holding of the court, just what they decided in the case. And lastly, your disagreements, your dissents, and your concurrences. Here are some additional things that you can put. I put these things too. You want to talk about the law in question if they're striking down a law. Obviously, this is not applicable all the time, but a lot of the time, the court likes to strike things down on smaller technicalities than make broad sweeping judgments on laws. So it's really important to know the technicalities of how the means, you'll understand that later, are being carried out. The significance of the case, law has latitude. Everything that things rain down from a decision. And so you need to know why that matters. Sometimes you don't. These dissents and concurrences can start trends in the court. The more dissents there are, more popular a kind of ideology will become among the justices of the federal courts, and I'm sure our state courts as well. So we should look at trends if we can recognize them. Lower court decisions, of course, you need to know if it's being affirmed or, struck down for whatever reason. And then historical events, what I really mean is current events from the case at the time, and or other cases that were decided on somewhat of the same basis in a very short amount of time that can really sway the way the court is going to decide in a case. So you should try to record that if you can find it. Mmootcourt, obviously, we have to use these cases for our argumentation. And so I try to keep a list of these key concepts that are talked about in cases, keeping it very general. I'm going to do an example of all this, so don't worry, but keeping a very general list of just the kinds of things that are covered in this case. You will understand once you have your case problem, but there will be two sides, a petitioner and respondent, and you might be able to recognize if this case would help the petitioner or this case would help the respondent. Of course, you want to make note of that. And then quotes on Hustia. You can get them if you just click case. So here is the example I am going to do. A friend reminded me of this case because of the recent uptake in hate crimes against Asian Americans and Asian people living in America. And so maybe consider this a history lesson. It was given to me in a history lesson. So here I am. In 1942, we are in the middle of World War II in the United States. And 2 months after Pearl Harbor, FDR signed Executive Order 9066, which designated areas of the United States. The Secretary of War could designate areas of the United States as military areas, and they were confirmed by the Congress. And so they were able to exclude people from certain groups from this executive order, which was to exclude people of Japanese ancestry from these specific military zones. This man, Fred Korematsu, was a resident of San Francisco. He didn't want to leave his home after he was forced to. This little poster right here shows what the people of Japanese ancestry in the United States were told to do when they were forcibly removed from their homes and taken to settlement camps. So he sued the United States government, saying that the executive order violated his due process rights from the Fifth Amendment. So the constitutional question here is, basically, did Executive Order 9066 violate the Fifth Amendment, and did it go beyond the war powers of the executive? So this decision was decided for the United States 6-3. The majority opinion was authored by Justice Black, in which, of course, they found for the United States. So they said that Executive Order 9066 was valid insofar as they were able to interpret the power of the executive in a time of war, which the precedent is quite broad from the Civil War. This and World War I. The fact that Congress had affirmed the military areas added to the deference that they showed them, but which is kind of counterintuitive because they they did something that was inherently suspect, which was to separate people by their national origin. But the court found that there was no invidious racial prejudice shown in that act because they were only relocating Japanese Americans. For the United States government was arguing that they had to institute these military zones and remove Japanese American immigrants and Japanese Americans because they posed a threat to national security. So national security is a wonderful, compelling interest, which brings me to our strict scrutiny test, which was actually created out of this case, which is ironic at best. So the first prong of this strict scrutiny test is that you have to have a compelling state interest. Just want to say again, the law's rhetoric, because the step down from this level of scrutiny is substantial governmental interest. So whatever. Compelling governmental interest. And your means have to be narrowly tailored to the government interest. So they can't do anything but achieve the government interest. If they're causing other effects, they're not narrowly tailored to achieve the government interest. And one of the things about this test that makes it difficult and strict, hard to pass, is that the means have to be least restrictive. So this is essentially narrowly tailored, except least restrictive means there cannot be any more restriction upon liberty than is absolutely necessary to achieve the governmental interest. So the thing about least restrictive means is that if the governmental plan in which there's this violation of liberty, in which they need least restrictive to pass least restrictive means, if their program is not working, it does not pass least restrictive means, because that would not be least restrictive if it's not working because it's not covering the governmental interest. So this case was also decided because of Hirabayashi versus United States, which was just a couple years before with the same executive order, and they ruled on the curfew. So if we're thinking more in depth, more Mmootcourt, I guess, about this case, we would want to think about the fact of the circumstances, which were Pearl Harbor attack on the United States. That was one of the first foreign attacks on the United States in a while. And I pulled a quote from this case, which I will read to you. It should be noted to begin with that all legal restrictions which curtail the civil rights of a single racial group are immediately suspect. This is not to say that all restrictions are unconstitutional. It is to say that courts must subject them to the most rigid scrutiny. Pressing public necessity may sometimes justify the existence of such restrictions. Racial antagonism never can. So this is a great quote from this case. And for me, I'm thinking that this quote would be able to help me on a governmental position. In this case, one of the things of note is that, of course, the strict scrutiny test was created. This is the harshest test that they have in the Supreme Court. This test is used for a lot of things. This test is used for affirmative action cases. One of Ruth Bader Ginsburg's big things was trying to use the strict scrutiny test for gender discrimination. Basically, there's a lot of reasons why you would use strict scrutiny. They use it in the First Amendment, and the case actually wasn't decided. They used the most strict form of scrutiny, and it wasn't decided for the petitioner. It was decided for the respondent, the government, in the case. So what does that say about this test, I guess? The that the most strict form of scrutiny was created for this case specifically, and it was decided for the United States even. So I would say that this case benefits a stay position, but you can decide for yourself what this says about this test. But it's interesting, the roots. How did I make this video? Just going back to resources, which I already shared with you guys before. I just Wikipedia'd this case. This case is quite famous, so it has a Wikipedia. There is an embedded link for a Wikipedia of the executive order. I read that. Korematsu, Oye, I read that. I read the Hustia version, which is just the court's opinion. And then I read a little bit about the Hirabayashi case in Oye as well. Okay, so I hope you learned something. Thank you, and welcome.